You're watching 13 WMAZ Law Call, sponsored by Macon law firm Reynolds, Horn, and Servant. Your rights, your calls, live. This is 13 WMAZ Law Call.
Well, hello and welcome to Law Call. I'm Morgan Dukes, and tonight we're going to be talking about medicine. Well, bad medicine. We're going to be dealing with medical malpractice issues, any type of medical neglect, anything that you might have a concern about. Tonight is the night you want to tune in. With me is the one and only Carl Reynolds. How you doing, sir?
I'm great, Morgan. Hope you are.
Yes, I'm doing well. And I see you brought some company with you, your partner.
BJ Servant is here to
Howdy.
give the answers to the hard questions.
Okay. I think together both of you are going to be able to handle this without a problem. And it is important, I want to say from the beginning that, you know, if anyone does have a medical malpractice question, they can always give you a call, right?
Correct.
Okay, so we want to...
Happy to talk to anybody who has a question about whether or not they have a malpractice case.
That's important. So we want to get into that tonight and even some definitions. So gentlemen, are we ready to tackle our first email question?
Sure.
All right. Well, the first one comes to us from Diane, and Diane's question is simply this: how do you determine if an injury due to a surgery is because a doctor was neglectful or if it was just bad luck?
Okay. It's easy. You have to have an attorney get the records and have a doctor look at it. Intraoperative injuries are particularly difficult. It depends on what the procedure was and what happened. It could have been a risk of the procedure, in which case there is no actionable case, or it could have been something that should not have been done during that particular surgery. BJ, I think you've had two in recent history where the injury occurred at a point in the patient's anatomy where the doctor shouldn't have even been. Can you tell us a little bit about that?
Yeah, we had one, it's been a few years ago now, where the doctor was doing abdominal surgery, and nicked the renal vein, a vein to the kidney, which was not in the area, supposedly was not in the area where he was doing the surgery. And when our client, unfortunately, the bleed started and could not be controlled, and he ultimately died after what was routinely a routine surgery, a simple surgery. But the doctor, we filed the case, and the doctor testified that, I didn't do that, I didn't cut it, I wasn't anywhere near there. And he had no explanation for what happened or how the autopsy had shown that the vein had been cut. He tried to suggest it was a tear done by the EMTs or the medical personnel when they're trying to resuscitate the patient, but it was not a rip, it was a cut by a scalpel. So he did it, and he just lied about it. But yeah, if, like Carl says, if they're not supposed to happen, they're actionable. If you're doing abdominal surgery and you got a bunch of, like a girl, you got a bunch of adhesions, and you nick something, that might be okay and within the standard of care as long as you saw that you nicked it and you treated appropriately to fix it. But generally speaking, if it's a risk of the procedure and it happens, that's what you sign the consent form for. That they happen. Unfortunately, bad things happen to good people sometimes.
But to the point of the question, the only way that the patient can find out is to see an attorney and have the attorney order the records and have a doctor look at the records and answer that question as to whether or not it was something that was done from professional negligence, or the key word there is whatever happened, does it fall below the acceptable standard of care in that profession generally? And that the only way you can get the answer to that is through an attorney who has to then depend upon a doctor for the answer to the question. Okay.
And speaking of nicks, our next question comes from Ken, who has a question that deals with that. So let's get into that. His question simply is: my cousin had a routine procedure that ended up with her intestines getting nicked. She was really sick for a month until they discovered the problem. And the hospital is blaming the surgeon, and the surgeon is blaming the hospital. Who do you sue in a case like this? What should Ken do?
BJ?
I thought that was yours, Carl, but
Oh, I'll take it.
no,
Yeah,
but
we have many cases
right.
like that.
We talked about this a lot. Yeah.
There are oftentimes actions that happen during surgery that simply don't involve negligence, and that is a risk of the procedure. You have nicks to the intestine or nicks to the bladder. They can cause a lot of mischief in the patient. Oftentimes, then it turns around the question of how long did they take to diagnose the cause of the problem? And that then becomes another case on another issue, which is delay in diagnosis. That's the simple answer to it.
Yeah, and
Okay.
get the who do you sue part of it, if they're blaming each other, you sue both of them. I mean, you sue everybody that's in the room and has some responsibility that led to the injury.
Okay. Well, bad medicine is our topic for tonight. That's what we're talking about with Carl Reynolds and BJ Servant. Gentlemen, let's continue with an email question from Adrian. Adrian has a medical malpractice question. You have to say that really slow. Medical malpractice. And her question is a MRSA infection considered medical malpractice? Can you begin, first of all, by defining what MRSA is? What is that?
That is generally the way they refer to what is called a MRSA staph infection. And the sad fact of the matter is that anytime you go into a hospital, you are at risk for getting an infection. Hospitals do all they can do. Most hospitals have protocols to prevent infection, but there's always a chance that you will get an infection. It may be a staph, it may be one that they can treat and get rid of easily. MRSA is a particularly bad one that can cause a lot of bad effects. But generally speaking, since it is a risk of going into the hospital, it is not. I don't know if I've ever told the story before, but we had a client. We actually sued an oil company because there was a splashback from a gasoline pump, and he was badly burned, and he was helicoptered over to the burn clinic in Augusta. And the thing that usually causes death in those cases is either dehydration or infection. So it kind of plays into both cases. But on that particular case, this client had been there for almost 6 weeks, and they had done the stuff that they usually do with the burn victims by putting pigskin on him and doing the daily routine that they did. And then in 6 weeks, he was actually up and walking around with a robe and bedroom shoes. At about the same time, there was a young man who was in a bad wreck 100 miles away. He was also flown into that burn unit. He had a staph infection when he was admitted. He was badly burned. That's why they sent him to the same burn unit. He was admitted to the same burn unit with a staph infection, and the staph infection ran rampant through the entire burn unit in that hospital, and every single patient died, including ours. We looked at, the case against the gasoline company for the flashback, of course, went on. Any potential case, however, against the burn center was investigated not only by us, but by several people. And they follow very strict protocols, and they're very compulsive about the way they do it. There was no negligence on the part of anybody in that hospital or that burn unit. That goes under the category of what BJ mentioned earlier. Sometimes just really bad things happen to good people. And I'll add this, that in those kinds of settings, the physicians are all good, and they're all caring, and they're all there to help people and eliminate pain and cause healing for injuries and for sickness. It's very rare that you actually have a clear medical malpractice.
Okay. Mr. Carl Reynolds, BJ Savant, those are our attorneys tonight. We will be back with more of your questions right here on Law Call.
You're watching Law Call on 13 WMAZ with personal injury attorney Carl Reynolds, who has recovered more than $500 million for his clients, dedicated to helping injured Georgians for more than 50 years, plus support from his Macon law firm of Reynolds, Horn, and Servant, including attorney Wendell Horn, focused on protecting the rights of car and truck wreck victims across the state, and attorney BJ Servant, aggressively representing those injured by medical malpractice, hosted by award-winning broadcaster Morgan Dukes, featuring guests from across Middle Georgia. Your rights, your calls, live. This is Law Call on 13 WMAZ.
And welcome back to Law Call. I'm Morgan Dukes. With me tonight is Mr. Carl Reynolds and BJ Savant from Reynolds, Horn, and Servant right here in Macon. And they are here to answer your questions. And that's exactly what we're doing tonight. We're getting into some bad medicine questions. And gentlemen, our next email comes to us tonight from Grace. And Grace has a cosmetic question. I mean, this is kind of interesting because cosmetic surgery is a popular thing, but her question has to do with getting a nose job. She says, I got a nose job 6 months ago and my nose is more bent now than it was before the surgery. How is medical malpractice determined in a cosmetic surgery situation? And by the way, her doctor thinks he did a great job. He thinks it was a success. So what is Grace to do, BJ? What should she do in this case?
Morgan, I feel sensitive to this question given my schnoz, but I think I can follow. To answer the question, rhinoplasty is what they call the nose job, the big word for it. But essentially, it's the same issue as any medical malpractice case. You have to prove the doctor violated the acceptable standard of care. So if the doctor did everything he was supposed to do or she was supposed to do, and it just ended up a little bit off, then there's probably not medical malpractice there. But like anything else, like Carl said earlier, contact the lawyer will get the records and have a doctor look at it, and the doctor is the one that says yay or nay on whether the standard of care was met or not.
I will say this. We've done a number of these over the years. In fact, a lot of them. And it seems to be that people who want to have cosmetic surgery, whether it's a nose job or a breast augmentation or a breast reduction or liposuction, I think in many, many years, we've had maybe two, BJ, that really worked out as something that was actionable. Most of the time, the person who's having that work done is the most critical of it afterwards, and they oftentimes are just difficult to satisfy. Now, if you want to hear a horror story, we had one where a lady went in. She was having she had breast augmentation, and she was having that removed and a breast reduction. And the physician who was doing that was a plastic surgeon. The afternoon before the surgery, he'd gone to watch his son play in a Little League game, and he had taken 2 Lortabs and drunk a quart of hot beer. And he came in and then started to perform the surgery. During the surgery, he was perspiring. He dropped his scalpel, picked it up, and continued the surgery. And the end of the story is she got a terrible infection and lost all of the tissue on her chest and had to have many implants done. I mean, many skin revisions done then. That was one. But as far as just the look, they have pretty wide latitude when they're doing cosmetic surgery. So again, we just have not found that the most time people who come in with that kind of complaint, it's in the eye of the beholder. If it's the person who had the procedure done, they're not satisfied. But I've never seen one that rose to the level that it was actionable.
Okay. All right. Well, our next...
There was one, in Savannah years ago where this plastic surgeon decided he would experiment, and inject a bad place on the lady's face with something that he had concocted.
Oh.
And unfortunately, she lost all of the skin on her face, and it was a record.
Wow.
Settlement in that case.
I'm sure. I'm
You
sure.
do find those situations, but it's very rare.
Okay. Okay, then. Well, let's move on to our next email question, because Caitlin has one that most of us have experienced just simply by watching television. And her question goes a little something like this. I see commercials for lawyers talking about dangerous drugs. If there is a class action suit, do I have to join in it to get compensation, or can I sue on my own? I'm sure many people have wondered about Caitlin's question. Do I have to join in or not? BJ, what do you think?
You don't have to. It's an optional thing. The advantage of joining a class is you've got a bunch of people sharing the expense of pursuing the case. And so you're not hiring the expert on your own dime. You're sharing with all the other claimants in the class. You also have the added leverage of the lawyers representing the class represent a whole lot of people against the defendant, not just one person. Flip side of that is you have almost no control over your case. So, it's a personal decision about what's best for you, but you can contact a lawyer that doesn't do it, but knows or familiar with class actions, or you can do it with a lawyer specifically handling that drug type cases, and he can give you an overview, or she can give you an overview.
Okay.
But you don't have to join the class.
Carl?
You don't have to, but there are many advantages in doing it. If you want a very basic course in how they work, go to Netflix or whatever and watch Erin Brockovich. That was sort of what that was about.
Okay. All right. Well, gentlemen, we're going to take a quick break. And then when we come back, we are going to deal with some cases that involves grandparents. We all have had them, and we know how dear they are to us. So stick around for all of that. I'm Morgan Dukes with Carl Reynolds and BJ Savant, and you're watching LawCall. And welcome back to LawCall. I'm Morgan Dukes. And you know what? Tonight with us, we have Carl Reynolds and BJ Savant. Both of them are from Reynolds, Horn, and Servant right here in Macon. And you can reach them if you have questions about personal injury, bad medicine, or anything you might be personally going through. The number to call is 478-405-0300. That's 478-405-0300. Be sure to follow them on the web at ReynoldsInjuryLaw.com, and Reynolds, Horn, and Savant on Facebook is where you can find them to find out about some other things that they're doing and see some nice pictures of some of their cases. Now, speaking of pictures, Mr. Reynolds, you are looking good with your brace on there. You're a picture of health tonight. You're looking good.
Well, thank you, Morgan. As I say, I keep hearing that I'm gonna get it off any week now, but they keep delaying the decision. As it stands right now, I'm supposed to wear it through the end of August, and then I'll be good to go.
Okay, then we'll keep on wearing it because it looks good and you look good. BJ, you always look great, always look good. So you keep on doing what you do.
Whatever, okay.
Whatever it might be. Well, let's get back into our email questions. And tonight we have one from John, and this one is a heartfelt one because it concerns his grandfather. He says, my grandfather died from lung cancer last year. He had been sick for several years before he was diagnosed. I think the doctors screwed up and they should have diagnosed him earlier. Then maybe he would have had a better chance of survival. Can you sue over a misdiagnosis? Not diagnosis. Can you, Carl?
Yes, of course you can. But the way those cases turn, it usually, sometimes it's a complete miss. In fact, we have the very first medical malpractice verdict ever rendered in Bibb County, and that was in 1984. Our client was a wonderful young man, 24 years of age, and he went for a year with a type of cancer called a neuroblastoma. I had met him before he became a client through a friend of mine. I was fencing some property I had for cows, and he and I worked together on that fence. I actually dug post holes together, and a few years passed, and he came back to see me, and he said that he had been diagnosed with cancer and only had a year to live. And could we help him with it? What he had, he was, I think, 24. He's just a wonderful guy. And he was described by some of the treating physicians as angelic. That was the kind of person we were dealing with. His cancer was a neuroblastoma. Now, neuroblastoma is generally a childhood cancer. And as I said, this fellow was 24 years of age. But he went through first one doctor, then a second one who happened to be a chiropractor. And they kept telling him it was just a muscle pull. Then he went through a second medical doctor who treated him for 6 months, and finally got to the hospital and was diagnosed with this neuroblastoma. And to the credit of the physicians who were actually treating him, they came in and basically testified as to the negligence on not only the failure to recognize it, but the delay in the diagnosis. I think the verdict in that case was $1.6 million, and that was in 1984. I'll never forget that case. Over the years since then, we've had many, many cases that involve cancer. And the deal is, if they miss it, yeah. And if they miss it, then what is the effect of them missing it? Or how long did it take for it to be diagnosed? And was the delay in the diagnosis, did that cause any additional damage or harm? Sometimes it doesn't. Some cancers are very slow growing, and they may miss it. We had one where a fellow had a tumor, and it involved his bladder. It was missed and found a year later, and he had to have his bladder removed. But it didn't make any difference in the ultimate outcome. So there was no harm, no foul, no injury. It's really what is, again, going back to causation, what did the delay cause in the way of additional harm that the question turns around?
And sometimes the life was salvageable, sometimes it wasn't. They would have lived a few more years or a higher quality of life for a few more years, or some, damages you can link up to the delay. Sometimes it's crystal clear whether they missed it, and had they timely and properly diagnosed it, the person would have survived full recovery.
And with grandparents, you just never know. You don't know what that time frame is. With anyone, you really don't know.
It doesn't really matter whether you're a grandparent or a grandchild or a parent. I mean, with cancer is rough stuff. It all turns around what kind of cancer it is and whether or not it should have been diagnosed, and if not, what did the delay cause anything additional in the way of injury?
Right.
Okay. Well, I tell you what, if anyone who's watching right now, if you have further questions for Mr. Carl Reynolds or BJ Savant, you can reach them right here in Macon at Reynolds, Horn, and Savant, 478-405-0300. Gentlemen, I want to thank you so much for being with us tonight, and I hope that we certainly have answered some questions for a whole lot of folks. But until we meet again, I'm Morgan Dukes, and on behalf of all of us here at LawCall, good night, everybody.
Good night, everyone.